Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law. And today we have three authors with us. Stephen Yeazell, who is the David G. Price and Dallas P. Price Distinguished Professor of Law Emeritus at UCLA Law, along with his colleague, Joanna Schwartz, who is the Honorable Harry Pregerson Professor of Law at UCLA, and Maureen Carroll, who is a Professor of Law at the University of Michigan. And all three of our guests are experts in civil procedure and are here to talk about their forthcoming book, or maybe just came out book, Civil Procedure, the 12th edition. And that's put out by Aspen Publishing. And congratulations on the 12th edition.
Thanks very much.
I was reminiscing with you all, and you reminded me that we did the 11th edition on the podcast too. And I've only been doing Aspen's podcasts for 3 years. So you all have been busy, busy, busy. Tell me what people will find in the latest edition and what makes you excited about this highly popular casebook for civil procedure now in its 12th edition.
Well, I'll take a first stab, and my co-authors can add on or correct me where I have strayed. But this is a book that has had many, many editions, has had a long life. And I think the goal of the book always has been to create material that is really user friendly, both to the fledgling law student who is just learning about civil procedure, probably certainly in their first year or their first semester of law school, and also to make the experience interesting and manageable for the faculty who are teaching these students. So that has always been the goal. I think there's a couple of different ways in which we're trying to achieve those goals with this next edition. One is not substantive, but it is simply making the book more readable. The prior edition, in an interest of saving pages, had a font size that was quite difficult for people to read. We took note of that from feedback from our adopters and simply have adjusted the book to make it a little more actually readable. Another thing that we did is we are constantly in our efforts to try to manage comprehensiveness, but also manageability, to figure out how much of cases to give to our students and our adopters. And the personal jurisdiction cases in particular seem to multiply every edition, and there are more and more cases. We cut them to be smaller and shorter in the 11th edition and have re-expanded them to some degree in the 12th edition to make sure that we're capturing all of the nuance. And then we're always trying to find the best cases to illustrate the various rules. So we've made some other adjustments in those places. I should also say we work hard to have a really comprehensive teaching manual for faculty who've adopted the class, so that when they are looking at a new day's material, they can get real insight about how to think about teaching those cases and that material. We've also given a PowerPoint that faculty can use themselves or build upon with close to 200 slides, so that they can have a base to work from as they're building out their class.
Let me throw one more thing about the teacher's manual, which we spend every edition a substantial amount of time on. This time around, we have not only at the end of each chapter so-called assessment questions with analyses in the book, but we have provided additional assessment questions that do not appear in the book, which we have found, at least I have in my classes, a really wonderful way of checking on the students' comprehension and uncovering misunderstandings. And so we have for each chapter additional assessment questions that are not published in the book, but which the instructor is free to use.
And in the same place that people can find the teacher's manual and the PowerPoint slides, we've put together a bunch of case materials for many of the cases that are covered in the casebook. So things like complaints and motions and things like that, so that those are available to sort of illustrate, well, here's what an RFA looks like and things like that.
And I should want to give a shout out to Maureen, who assembled all of those. Thank you.
I assembled some. I want to give a shout out to Joanna, who also did.
Okay.
Well, we all shout out each other.
I did not assemble any of them.
What a collegial group of authors. Well, that sounds terrific. I mean, nearly 200 PowerPoint slides and all those assessment questions at the end of each chapter to underscore the comprehension of the students, plus additional questions in the teacher's manual. Sounds like a very student and faculty friendly book. I'd love to know, in the course of all of these editions, what are some of the themes that you've seen change the most, if any, over the course of civil procedure for 1L students?
It's a great question. I'm not sure I can answer, but let me have a stab. In addition to the sort of metastasizing of the personal jurisdiction cases, which have made the teaching of that area much more challenging, and indeed the problem is how not to have that portion of the course just take over the entire semester. So that's been one thing. I think there's been increased interest in procedural tools and devices as implementing lawyers' strategy. That's something we certainly try to explain in the book. So we regularly ask students not just, why they're trying to get the case dismissed on such and such a ground. Why do you suppose they did that? How did that motion implement what you might infer about the lawyer's strategy of the case? So I'm not sure that's a change in civil procedure as much as it's something that's we've emphasized. Well, let me stop there. What do you guys want to add?
Well, I graduated from law school in 2009, which means that when I took 1L civil procedure, Iqbal had not been decided yet. So the question while I was in law school was, is Twombly going to apply to all cases or just large antitrust actions? So that is, just from when I took it, is such a big change. And this was the casebook I used when I was a student and continued to use it when I started teaching. The other thing is, I think that civil procedure is interesting because you can take it as, like Steve said, a course about sort of litigation strategy and how you can use the tools as part of litigation strategy or to implement strategy. You could also teach it as a course that is more about what is a court, how do we decide where an appropriate forum is, what does it mean for a forum to be appropriate, all of those types of questions. What is the appropriate balance of power between states and federal courts? And I think that has in some way grown in terms of the case law that you could draw on for that, because a lot of the personal jurisdiction case law gets to it. But my sense, and I'm curious if my co-authors see it this way, is that there's been more of a move toward the strategy type of approach in the way that the 1L course is taught.
Certainly the way in which I teach the class, I really love teaching the life of a lawsuit and all of the strategy involved and put that first. Steve and Maureen and I have all talked at various times about how to structure the course. And the two main options are to do jurisdictional issues first, and then things that what we call life of a lawsuit starting at chapter 5, or to go the other way around. And I personally really like talking about the life of a lawsuit first, starting with chapters 5 and 6, because I think that it gives students a sense of what the stakes are in these cases and why procedure matters, why procedure can affect the end result of a case. So to me, it's a very fruitful way to teach the class, but hopefully the book is written such that people can make either choice depending upon their preference. The one other area that I would add in that I think is affecting us all in a variety of different ways is technology and artificial intelligence. And I think that the rules are trying to catch up. Discovery rules are trying to catch up with electronic discovery. We have a new case that will be in the 2026 rules supplement that is a case about a Rule 11 case, a sanctions case, where a lawyer has let a computer do its legal research for it. But these are issues that I think are perpetually coming up in legal practice. And as a author of a case book, there is a challenge to stay up to date with these changes as they happen, but also to maintain the broad scope of and reach of the book and of the class.
But let me just underline something Joanna said. We have made an effort in the book to legitimize whichever approach the instructor wants to use, the jurisdiction first or the resolution of contested matters of law and fact first. We have an introduction to each of those sections, which says explicitly, you can go bottom up or you can go top down, and all courses will cover both topics, but yours may do either. So everything we can to make legitimate whichever approach the instructor wants to use.
Well, that flexibility must be really very attractive to the professors considering your text for use in civil procedure. I'm wondering, I think there are more issues related to civil procedure in the news these days than one might typically find. And so I was wondering, are your classes becoming intrigued and curious and bringing those inquiries into the classroom? And what sorts of things are they finding or you finding most interesting facing our current challenges nationally with civil procedure?
I would say that in years past, it has been, well, and it remains true, but our administrative law colleagues, our constitutional law colleagues are the ones dealing with the issues that are pulled from the front page of the newspaper. But there was a lawsuit that was just dismissed on Rule 8 grounds within the past week that made a lot of news. And you don't think of Rule 8 as necessarily being so splashy, but I have found that when these topics come up, or the appealability of a request for injunctive relief and the importance of whether injunctive relief is stayed or not while the case is on appeal, these are all issues that I have talked with my students about. I find that sometimes students want to raise these issues in office hours, and I'm more than happy to talk about them. But I do also, when I feel compelled to do so, I do bring up cases that have made the headlines to try to reflect what is happening. And one of the three key things that I tell students at the very beginning of the class, I tell them that lawsuits have rules, lawyers know the rules, and rules affect outcomes. And I think this rules affecting outcomes is a theme for me throughout, that procedure matters, in other words. And offering them examples from the headlines of the importance of procedure is something that I try to do whenever I can.
All of that is absolutely true. I taught a discovery case yesterday out of the New York Times having to do with expert testimony. Let me flag something that, Patricia, you asked about a little while ago that has finally come into my mind, sort of new themes, changes in procedure. I think one of the terrible challenges facing this new generation of lawyers as they teach them is the increasing proportion of unrepresented parties. Joanna reminded me of it when she said cases have rules, lawyers know the rules. Well, we have a party-driven system or a lawyer-driven system in which we assume that the lawyer will know what a discovery cutoff date is. But if an unrepresented litigant has no idea what discovery is, much less what a discovery cutoff date. So one of the things I keep telling my students that they are going to need to figure out is how to deal with this rising tsunami of unrepresented litigants. What are we going to do? It seems unimaginable that we're going to expand legal aid to cover all of them. Our court's going to have to become, the judge is going to have to become more involved in the cases themselves. Are we going to create more non-lawyer, sort of paralegal type assistance? But that's a topic that I have found myself dealing with increasingly in recent years.
And that's one of the things I like about one of the new cases that we're adding in this edition, Bluegrass Marine. It's a default case against someone who initially was unrepresented. And so when he got the complaint, he called the person who had sued him and said, "What's going on here? This has nothing to do with me." And he thought that was all he needed to do, right? He thought, yeah, exactly. He thought that was an answer because he literally answered. And that's a very common situation for defaults and default judgments, is that the cause of the default, or at least a circumstance of the default, is that the defendant is unrepresented.
Right. And maybe the defendant has no real defense on the merits, but maybe, as in this Bluegrass Marine, maybe he does. He really wasn't involved.
Well, I know that judges here in Texas are very concerned about that. I suspect judges across America are concerned because of the pro se litigants. It certainly puts the judges in a difficult position, opposing counsel in a difficult position, but most of all, the litigants themselves who don't understand the rules and the gatekeeping and that there is a Rule 8 or whatever the case may be, or that, you can't use AI cases and rely on them or procedures. So that will increasingly become an issue. I think about multidisciplinary litigation and class actions. I know some of the recent headlines involved injunctions that then were going to become class actions. I mean, I will say civil procedure seems a little flashier recently than it has been historically. So
Hard to imagine, but yes, Every dog has its day.
That's right. This is your moment.
Yes.
And we do have our chapter 12 is on joinder issues, and Maureen and Steve are both experts in class action litigation. And Maureen, especially when she joined the casebook in the last edition, really did a wonderful job of updating that last chapter and bringing out all of the complexities of multi-district litigation and class action litigation, so that's another choice that faculty can make when they're adopting the book, is to figure out how much of that material they can fit in. But it really can support at least the beginnings of a complex civil litigation set of materials.
That's one of the trends, since you were asking about trends earlier. Multi-district litigation cases make up, by some counts, more than half the filings in federal courts currently. So it's a huge proportion. And there are lots of different ways of measuring how much of the litigation is actually happening there and things like that. But there's by any measure, there's a lot of it happening. So I think it's worth taking on.
And it plays into this very much into this culture of settlement, in which it's quite likely that both the plaintiff and the defendant's lawyers and the judge want, above all, not to try any of these cases, but to figure out how to settle them. So it's part of a kind of continuing conversation about the advantages and disadvantages of settlement. Settlement seems to end about, depending on how you count, 70 to 80% of all cases, but it ends essentially 100% of the MDL cases. And we don't treat the MDL stuff comprehensively, but students will certainly know it's out there and that exists.
That's great. And they will know the right name of it, multi-district litigation. I think I called it multidisciplinary litigation because I'm always thinking about multidisciplinary stuff in the academy. But it's certainly increasingly an issue that attorneys have to deal with because of the prevalence of it. 50%, that's extraordinary. So as far as, let's get back to the 12th edition of the book, how has it been different for you all to use this 12th edition, because I assume you're all using it in your teaching, versus prior editions? What do you as instructors appreciate about the book, or have differences you've seen of the impact of the book, besides the readability, which I love as a woman who's aging?
Yes, exactly.
Bigger, clearer font sounds great to me.
Well, actually, the book just came out, so confession, I think neither Joanna nor I is actually using it this edition in this year's classes. So let me flag something that was in the previous edition, but I think is increasingly important in this one as we talk about multi-district litigation, as we talk about, controversies about nationwide injunctions and so on. I think the real struggle in recent years has been how to keep the personal jurisdiction material from basically swallowing everything else in the course. And one answer to that, there could be several answers, but one answer to that is we have prevailed on our extremely learned and distinguished colleague, Clyde Spillinger, to write a 25-page text summary of everything from Pennoyer through it, not only through International Shoe, but through Schaefer against Heitner. And I have in recent years used that in order to compress the first 100 years of personal jurisdiction cases into a manageable group, so you can then jump into the modern case. And I think that's important not only in its own right, but then that leaves time to talk about other things, other controversies, multi-district litigation, the nationwide injunction, the Rule 8 cases, and otherwise the jurisdictional stuff just swallows up the whole course.
Well, thank you so much. And congratulations on the 12th edition of Civil Procedure. It's a landmark book in the field when it is just titled with the name of the subject. Very impressive. And so that is forthcoming, and you'll be able to use it soon. And if you're interested in using it, I hope you will check it out from Aspen Publishing. But before we conclude, I wanted to ask each of you a question I've asked you before when we interviewed you about the 11th edition. And that is, what are your predictions for the future of legal education in the coming decade?
I'll go first only because something has popped into my head, which is, again, sort of what role AI plays in the work that we do. I just had a student ask me if I thought it would be a good use of her time and of technology for her to feed her outline into ChatGPT and then ask ChatGPT to write issue spotter questions. for her. And I said, that sounds like an interesting way to do it. And I'd be curious to see what you explore. I think that as the case that we've added to our rule supplement makes clear, I'm not a fan of AI doing the work of learning, certainly of doing the work of researching. There's a case that we, sort of an old, very wonderful case, Hickman versus Taylor, which talks about the importance of not borrowing the wits of your adversary. And you don't really want to borrow the wits of AI either. But I do think that it is inevitably part of our future, and thinking about how best to use it, how constructively to use it, is going to be something that lawyers and law students and law professors need to be thinking about every day, certainly every semester.
I also think there's going to be a need to grapple more with what we mentioned about the rise in pro se litigation, because the nature of pro se litigation is that our law students won't be representing pro se litigants, but they will be opposing pro se litigants in many cases. And that's something that, even though we talked about it as a civil procedure issue, it also affects every area of law.
Yes, and I think sort of combining those two, it would require somebody much more knowledgeable than I to do this, but it is possible that AI may have a constructive role to play in helping pro se litigants represent themselves. Don't ask me what that might be. I'm way too old for that, but it's not unimaginable that there'll be some development there.
I had a podcast interview with a solicitor in the UK who has started a firm that is entirely AI. It's called Garfield. And what they do, speaking of pro se litigants, is they represent tradesmen, plumbers and electricians and those kinds of folks who have unpaid bills. And the AI spits out a demand letter and then does the follow-up and then does the pleadings and can do some of the answers. And it's actually received some big support from their equivalent of the Bar Association and has gotten approval to operate this way. And he's received inquiries from across the globe, as you can imagine, to see how this might be transferable to other areas of the law. So I do think, Stephen, to your last point, that there is a place where artificial intelligence and pro se litigants can be married in a way that's very effective to access to justice, but I don't know that we're there yet.
I certainly don't.
Well, I want to thank you all, Maureen Carroll, Stephen Yeazell, and Joanna Schwartz, for discussing Civil Procedure 12th edition from Aspen Publishing with me. And if you enjoyed this conversation and want to listen to additional legal education thought leaders, you can find our podcast on YouTube and Spotify and Apple and other places you find your favorite podcasts. Thanks so much.
Thank you.
Thank you,
Thank
Patricia.
you.